Uh-oh. The dogs are going crazy. I'm here. Apologies to everybody who waited. I don't know what's going on with those. Sugar Bear and I had a rough night. He wasn't asleep by 8, and when I went to put him to sleep, I fell asleep with him. We're gonna go over Katie and Charlie being transferred. The request went in for the transfer, and then the Sigfredo, I posted that on the community tab, or the post tab, I think it's called now. Donna wants to do a depo on him. And then Judge Everett wrote 2 beautiful motions: the order denying her bond, thank goodness, and then the order denying the suppression. I'm going to go over the bond first. The denying the suppression is 9 pages. I'll do that last in case there's people who don't want to hear the whole thing, but it's pretty spicy. And it gives, both of the orders actually give a lot of insight into what Judge Everett is feeling about the case. And if it's not a, like, girl, take a plea, I don't know what is. Honestly, I don't know what is. But let me run this intro before I forget, and then we'll get into this order denying motion to set bond Arthur hearing. All right, let's get into it. Our wishes have been answered. Might have, anyway. We're one step closer to justice for Dan Markel. Okay, order denying motion to set bond. This cause came before the court when the defendant sought review of her bail status based upon State v. Arthur, which is the Arthur hearing. The court, having reviewed the evidence, admitted during the February 26, 2025 hearing the arguments of the parties, the court file, and being otherwise fully advised in the premises, finds and adjudges as follows. Defendant is charged by indictment with a qualifying offense, first-degree murder, and the state has come forward with a showing that the proof of guilt is evident or the presumption is great. State v. Arthur, right? Everybody is innocent until proven guilty, but the presumption of guilt is evident or great. Checks to Katie McBanawa, phone calls talking about this TV cost $5, direct evidence from Katie McBanawa in Charlie's trial that Miss Adelson was involved, that she was receiving checks and she never worked for the Adelson Institute. The evidence from Charles Adelson's trial, viewed in the light most favorable to the state, demonstrates, number 1, the defendant's personal and unique motive to assist, cause, or encourage the murder of Dan Markel. Number 2, the lengths defendant was willing to go in the custody battle involving her grandchildren. Number 3, testimony by Catherine McBanawa directly implicating the role of the defendant in the payment of the murder for hire. Number 4, payments made by the defendant to alleged co-conspirators. Little man is up. Following the murder. Number 5, text messages and cell tower analysis demonstrating defendant's movement on the night of the murder, which shows that she stopped somewhere. They're saying it's Charlie Adelson's house, which Katie McBanawa's testimony corroborates, right? That she took longer than would have been normal to get from her home up to Tallahassee. Okay. Okay. Oh my goodness. Okay, hold on. Oh my God, I got it on both other, what is it? On either side. Anyway, let me just see here. Okay. Mm-hmm. So, defendant's conduct after the law enforcement bump operation and communications on authorized wire tapped interception. Defendant also exhibited consciousness of guilt. She attempted to flee to Vietnam prior to arrest using an emergency fast track visa. Let me move these earphones, baby, so you're not laying on them. Okay, there you go. See State Exhibit 6. The evidence of flight is admissible as consciousness of guilt, where sufficient evidence exists to establish the defendant fled to avoid prosecution. See Shalito v. State. After the state meets its burden regarding Arthur, the court still retains the discretion to grant or deny bail. When determining this issue, the burden is on the accused to demonstrate that release on bail is appropriate. And they didn't address any of that other stuff, right? They only addressed for the bond hearing that she wasn't a flight risk, she would be on a monitor, her passport doesn't work, she's on a no-fly list, but they still didn't address like that she was trying to flee, and to pretend like it was a vacation, I think is just an insult to Judge Everett. It is with regard to this question that consideration of the likelihood that the accused will flee, regardless of the sureties required, becomes appropriate. So no echo monitor, no fly. I mean, she could commit suicide with her husband, and that is also technically fleeing. At least in my mind, you're getting out of being punished. No? Hot. Yeah, that is hot. That's mommy's tea. In reviewing the evidence admitted during the hearing and applying the bail criteria, Section 903 Florida statutes, the court finds that one of the primary considerations of bail, ensuring the appearance of the criminal defendant at subsequent proceedings, cannot be met, right? We can't, unless somebody is guarding her 24 hours, which then you might as well stay in jail because that's what they do. There's no reason for her to be out. One day after Charles Adelson was convicted of first-degree murder and other crimes, the defendant discussed fleeing to countries. Oh yeah, it's a unicorn. To countries without extradition to the United States. See States Exhibits 4 and 5. That same defendant communicated with Vietnam Visa Indochina Sun Travel through what she believed was a secure communication application, WhatsApp, trying to acquire a fast-track emergency visa for Vietnam, and wanted it the fastest she can get it. See State Exhibit 6. The purchase of a one-way ticket and seeking a fast-track visa for extended stay in a country without extradition clearly demonstrates an intent to flee and not vacation, Miss Adelson. The court does not find the testimony offered by the defendant during the evidentiary hearing on this subject to be credible, considering the evidence. Okay, baby. Mm-hmm. Are you going to have milk? Okay. Additionally, defendant's discussions of self-harm further negate, I'm glad he put that in there, further negate the possibility of appearance for subsequent proceedings as provided by the court. Hang on one second. Alarms are going off. Good morning, everybody. How are you guys? Hope the weather is nice. That is the device answering me now. The issues raised by the defendant concerning her conditions of confinement can be directly addressed through administrative and or civil remedies. In other words, Donna, why are you bothering me about your mattresses, ma'am, and your carbs? You think I have time for that? Do you think I went to law school to worry about your carbs and how much tuna fish you get, ma'am? Sit down. The testimony and evidence during the hearing clarify the reasonable measures taken by the Leon County Sheriff's Office to address defendant's concerns. Defendant is not being denied access to counsel or the opportunity to prepare for trial. The court also notes, wait for it, the defendant has undergone extensive trial preparation prior to the continuance of the trial on September 17th, 2024 through present. Done and ordered in chambers, Leon County, Florida, Monday, March 3rd, 2025. So it seems like he finished them both at the same time, but they posted a day apart because I sent you guys the note when I saw that the motion to suppress was denied, but the doc wasn't there. I do have it here today. I love that he also is pointing out, girl, you were on day one of trial when your counsel, Mr. Rashi, had to withdraw. So you should be prepared. And I wonder if that's like a little bit of shade of like maybe it's the attorneys that aren't prepared, because you remember the second to last hearing that we watched where they were basically saying they might need more time, and the judge was like, well, I'm not changing the dates, keep moving, and then we'll see how far you get. We still have well over 2 months to go. There is a foot and a hand. Okay, then we have, so I didn't, let me just look at you guys. I did not pull up. I posted the Sigfredo thing, but they are going, Donna wants to depose Sigfredo. Now remember, Sigfredo has not spoken at any of the trials, not his own, not Katie's, not Charlie's. And so he could just plead the fifth. I'm hearing he has a new lawyer. The lawyer was not copied on that. I'm sure it'll get forwarded because he has a right to have counsel present while they're doing that. Yeah, I just think it's interesting. If she had nothing to do with it, what angle is she trying with Sigfredo? I asked some of you guys, I think we're all a little bit stumped. Like, why are you calling him? Or why are you deposing him? Right? Because if she, they're going to have to give up the extortion theory. I don't know what they're going with. Take a plea, Donna, take a plea, admit your guilt. But if she has nothing to do with it and her son was extorted, why is she connected? How would she be connected to Sigfredo? We have that one call from Sigfredo to Harvey when he thought he was calling Charlie. But that's really, I don't know where they're going with that. It makes sense that they're bringing in Katie and Charles, although I'm imagining that Katie is going to probably, well, no, because Katie, she's incentivized to testify, right? Because she testified against Charlie. She's going to testify against Donna in hopes of a lesser, something less than life, right? Life plus 30. Or I think you guys told me it was life plus 60. I thought it was only Charlie, but one of you guys said it was life plus 60. So that's risky, because what if they just take off the 60 and they don't take off the life? You know what I'm saying? But I mean, at least she's being honest. That's the least she could do after all this. Okay, so this cause having come on for consideration and it appearing to the court that the named witness, Catherine McBenois, is presently incarcerated at Department of Corrections, Florida, blah, blah, blah. So she's got to come for the trial. She's got to be transported to Leon County June 5th through 20th is when they're looking for her to be there. And then that was sent out yesterday. Copies to Georgia and the Leon County Jail. That seems straightforward. She'll get a nice little break from wherever doing what. I think you guys said she was in law. I actually, hold on. Let's see. Did I not pull this? Yeah. Give me 1 second. Yeah, she's in law annex. So here she is. She looks so young. Threw her life away for, she was born in 84. So she's what, 40 something, 41, is that right? It's early. My math may not be mathing. And then we have Charlie, which I was wondering about because his says the same thing. It's like Florida Department of Corrections. I'm like, isn't he in South Dakota? He is, but his facility is there, but he's still under the care and custody of Florida. So I don't know, like, do you know how they have student exchanges? Do they have prisoner exchanges? Okay, now we're going to get to the delicious one. 9 pages of nice nasty from our lovely Judge Everett, who is like not about that life. Okay, it's a delay. Uh-oh, am I frozen? Good Lord. Okay, now I'm moving. But I look blurry. Okay, order denying defendant's motion to suppress. This cause comes before the court on defendant's motion to suppress, filed with the clerk on February 10th, 2025. The court having considered the motion, the evidence admitted, hearing the arguments, defendant supplemental memorandum of law, the court, and being otherwise fully advised in the premises. Okay. Finds as follows. finds and adjudges as follows. On November 7th, 2023, defendant received a phone call from the Leon County Jail to her cellular phone while she was at home in her apartment. The caller was her son, Charles Adelson. At the time, Charles Adelson was an inmate of the Leon County Jail, incarcerated there since his arrest on April 21st, 2022. And he was arrested before Katie went to trial. I think that was to incentivize her to take that immunity deal. She didn't. One day prior to the phone call at issue, Charles Adelson was convicted of first-degree murder, conspiracy to commit murder, and solicitation to commit murder, and sentenced to life plus 60 years. Before being permitted to speak with her son, defendant was required to acknowledge the following message and consent to its terms. The message disclosed, "Hello, this is a prepaid call from Charlie, an incarcerated individual at the Leon County Jail. This call is not private. It will be recorded and may be monitored. If you believe this should be a private call, please hang up and follow facility instructions to register this number as a private number. To accept charges and consent to this recorded call, press 1. To repeat, thank you for using Securus. You may start the conversation now." This preamble is a standard notification advising individuals who receive phone calls from Leon County Jail that the calls will be recorded. Thus, to speak with a Leon County Jail inmate through this phone system, the non-inmate must give consent to be recorded unless it is a private call. Defendant concedes she was informed of this notification when she consented to speak with her son on the recorded line, right? Because if she doesn't agree, there is no phone call. So there's no interception there. Approximately 8 minutes into the phone call, Charles Adelson was disconnected, leaving only defendant's phone. Oh, another Oregonian. Hello, Kelly D. Freaky at 2 times speed. Approximately, wait a minute. At that point, defendant said, "Can you hear me, Charlie? Shit. You can't hear me again, right? Charlie? Charlie, can you hear me? I'm sorry." The 4th time that they cut the line each time. She then began a lengthy conversation with other people who were inside of her home. Her estate planning attorney, the attorney's husband, and her husband, Javi. Given that defendant was conversing with people other than her son, referring to her son as he and him while talking about him, and revealing facts that she did not have the heart to tell him, the court is convinced defendant subjectively believed their shared phone call had ended and any ensuing conversation private. She subjectively believed it. Subsequently, over the next 15 minutes, defendant alluded to committing suicide, professed she was looking for countries that did not have extradition agreements with the United States, wondered whether Vietnam has an extradition agreement with the United States, and spoke about a conversation she had with her daughter, Wendy Adelson, about giving her papers and wills. Eventually, someone other than defendant, it was her estate attorney, the woman, realized that the phone call had yet to end and ended the call. It was only at this point that the phone call terminated and the recording stopped. Investigator Jason Newell testified, "This is standard protocol for phone calls originating from the Leon County Jail. You're not special, Donna. This is how it happens for everyone." Defendant argues it was an unlawful, warrantless interception to record her conversation after Charles Adelson was disconnected because she believed the phone call and recording had ended. If only the world went around what you believed, Donna. If only. Analysis. Before a trial court will consider the merits of a Fourth Amendment motion to suppress, the defendant must first establish a factual basis justifying his or her claim to have possessed a Fourth Amendment right at the time of the alleged invasion, Naminsky v. State. Regarding oral communications, for an oral conversation to be protected under Section 93403, the speaker must have an actual subjective expectation of privacy, along with a societal recognition that the expectation is reasonable, right? So she has the subjective expectation. He's agreeing with that. But does society agree does society recognize that the expectation is reasonable? And we are part of society, and we said no, because there was a pattern that he would join back on the line. If you've listened to the calls, they're over on Phone Calls from Prison and Pretty Lies and Alibis. There's multiple times where he actually does come back. And the defense made the argument that his was disconnected because he tried to call her back 3 times. I don't know if they entered that call log into the record. However, I'm wondering if, because it's coming from the jail and it's that secure system, if it's VoIP, like voice over IP, which means like he would have dropped that IP, and when he tried again, they would have given him a new one, so he was able to call out, right? It's not the same line, like if it's your house phone where you get a busy signal, do you know what I mean? Does that make sense? That's my theory anyway. Accordingly, to successfully claim the protection afforded by the Fourth Amendment, a defendant must demonstrate that he or she personally has an expectation of privacy and that this expectation is reasonable. State v. Washington. Defendant argued in her written motion that the state bears the burden of justifying its alleged warrantless interception and moved to suppress the oral communications she uttered after Charles Adelson was disconnected from the phone call. However, the written motion misstated the burden of proof because a Fourth Amendment search does not occur even when the explicitly protected location of a house is concerned, unless the individual manifested a subjective expectation of privacy in the object of the challenge search, and society is willing to recognize that expectation as reasonable. Society doesn't recognize any of Donna's actions as reasonable. Kylo v. U.S. As a result, it is the defendant who must first establish a search occurred within the meaning of the Fourth Amendment. See Washington, Hicks v. State, Rockus v. Illinois. To support suppression of a communication under the wiretap law, the person who made the statement must show more than a subjective expectation of privacy. They must show that they have a reasonable expectation of privacy under the circumstances, which demonstrates on one's actual subjective, which depends on one's actual subjective expectation of privacy, as well as whether society is prepared to recognize that expectation as reasonable. There's a smiley there. Because the court concluded defendant did not subjectively expect, this is about the other case, that her conversation was private, this motion turns on whether society is prepared or willing to recognize such subjective expectation as reasonable. So wait, the court concluded that defendant, did subjectively. Okay, so yes, he's in agreement. Her subjective opinion that it was private. So now he moves to the societal reasonableness. Okay. After conducting a thorough analysis, the court has determined defendant's conversation did not constitute the unlawful interception of an oral communication under Section 934, Reasonable Security Measures of Leon County Jail. To ascertain whether society is prepared or willing to recognize defendant's subjective expectation of privacy as reasonable, the court begins with the well-established principle that citizens are guaranteed a reasonable expectation of privacy in their own home. So they tried to loophole it because she was at home. State v. Mozo. The court, and so I think that it harkens back to like when they would put taps in people's home. Like there's some ruling that came later that forbade that. Because of course at home you're going to be relaxed, but there have been exceptions to those, as we know. Wiretaps like being granted. The court also recognizes that jails and correctional facilities have a strong interest in preserving and maintaining their security, and the interception of calls from inmates to non-inmates does not violate the privacy rights of the non-inmates. U.S. v. Willoughby, also Jackson v. State. Yeah, you won't be able to talk to them on the phone if you don't agree to have it recorded, because who knows what you might be up to. Jackson did not have a legitimate, reasonable expectation of privacy in a recorded phone call that was placed while incarcerated after receiving warning that the call was being recorded. Oh, yeah? Okay, can you let go of my headphones? And number two, the interest in institutional security allows jailhouse conversations to be monitored, right? Imagine if they're planning like a breakout or something. That's the only way. They monitor their calls, they monitor their tablets, they monitor their mail just in case. I mean, they are in the care, custody, and control of the state. So we want to know what you're doing, just like your mama wants to know what the 8-year-old's doing. In addition, it does not matter if the call is made to a non-inmate's home. Imagine that, because then that means if you wanted to get away with something, just call them at home and then that's protected. Like, that was a stretch. Nor do we find merit in Willoughby's contention that his own privacy rights were entitled to greater protection than those of Quentin because he received Quentin's call in his home. Thus, defendant relinquished her reasonable expectation of privacy when she answered her phone and consented to speak with her son. Defendant argues that she regained a reasonable expectation of privacy previously relinquished through consent once her son was disconnected, but she did not actually terminate the call from her end. She didn't hit the end button. It was still going. And I mean, we've heard, for those of us who've heard the calls, it's happened before. She didn't hang up on purpose and he would come back on the line. So just reasonably, it seems she was expecting him to return. So during the hearing, the state contended that the primary basis for denying defendant's motion to suppress was that it did not intentionally record defendant's conversation. The court disagrees. Oh, interesting. It was intentional because it wasn't nefarious. It was intentional in that it was part of the normal protocol. The Leon County Jail intentionally utilizes technology developed by the company Securus that, by design, continues to record conversations between inmates and call recipients until both parties disconnect. If the decision to record prior to the inmate's disconnect is intentional, as the state's argument concedes, it stands to reason the decision to record after the inmate is disconnected is also intentional. Right? Both ends have to terminate in order for it to be. Although I don't know that is the state's doing. I guess that's a word play, because it's not like Georgia Cappleman and Sarah Dugan called the jail and said only record Charlie's calls after he's disconnected. But I guess all of them collectively are the state. However, in determining whether an exception of privacy is reasonable, courts should examine the location of the conversation, the type of communication at issue, and the manner in which the communications were made. State v. Caraballo. Although the location of defendant's conversation occurred within her home after her son was disconnected, the fact remains she consented to receiving a phone call from a jail facility. The type and manner of the communication are also quite different from ordinary phone calls. The phone call, 1, began with a message stating it was not private. 2, required acknowledgement that it was being recorded. 3, required consent to proceed. And 4, utilized third-party technology to facilitate recordings between inmates and non-inmates. And she knew all that up front, right? She heard the message. She said it on the stand. She acknowledged it by not hanging up. And so that was her consent to proceed. And it said, I mean, it's an automated voice and it says, thank you for calling Secure. So that's the third party tech. Even if many modern cellular phone devices typically terminate a call when one party is disconnected, as defendant stresses, communications from jails and correctional facilities have unique institutional safety concerns that are not at issue in common communications between non-inmates. Thus, defendant's subjective expectation was built on a false assumption that dropped calls involving the Leon County Jail have the same result as dropped calls involving at least one cellular phone. Why she had that expectation, I don't know. And I'm actually going to call BS. Because there are too many times, too many phone calls, and I haven't even listened to them all, where it drops and he comes back. So I don't think she thought the phone was hung. Not that I'm in Donna's head, but I'm just saying, if she did, it wasn't based on the history of the phone calls. Let's put it like that. It was not reasonable because it was not what had happened in the past. For example, a federal court of appeals has remarked that the Bureau of Prisons recording system and the random live monitoring of telephone conversations have assisted in the detection of escape plans, of schemes to smuggle controlled substances into the facility, and of inmate identification of another inmate as an informant in the government's witness protection program. Ooh. Willoughby. There is no plausible reason why the Leon County Jail should not be afforded deference in how it uses a recording system to a safeguard against similar security concerns, including by continuing to record an inmate's phone call until both parties have disconnected the phone call. So I love that he's saying, I'm deferring to Leon County Jail. They know what they're doing. I'm not going to intercede. There's no reason why I, who sit on a bench, should be dictating to those who guard inmates how to run their facility. Okay. Prison officials must be free to take appropriate action to ensure the safety of inmates and corrections personnel and to prevent escape or unauthorized entry. Accordingly, we have held that even when an institutional restriction infringes on a specific constitutional guarantee, the practice must be elevated or evaluated in the light of the central objective of prison administration, safeguarding institutional security, right? And you think about it, like the guards are outnumbered all day, every day. So they have to do everything they can so they walk out alive every day. And who knows what is going on those phone calls if nobody is listening. And I don't know if they're actively, it says some of them are monitored, but in the event that something happens, they're able to go back. For Charles and Donna, they had it in real time because they were tracking her, getting the visa, getting all those things. The day she was arrested that morning, they were getting the warrant for her arrest from Judge Everett. And then I can't remember which, I can see his face. Was it? It's not Isom, it's the other one. But he drove down that day from Tallahassee to Miami Airport, like down to the wire to get Miss Adelson her new bracelets. Some inmates evade or break the rules, restricting their privileges. For example, the department's telephone security vendor can detect three-way call attempts by the clicking noise that occurs when a call is transferred. But inmates will blow into the receiver when transferring a call to mask that clicking noise. Three-way calls are not permitted because they want to know who you're calling. They need to be approved. If they hear something, they need to know who the other person is, etc. So, and as the federal courts have opined, it is difficult to imagine that the considerations that justify monitoring and recording of a prisoner's utterances could somehow not apply at the other end of the phone, right? That would be damn near impossible. The rights, basically when you're talking to an inmate, you are giving up some of your rights in order to talk to the inmate. The rights of free persons may well at times be implicated and stand or fall with the rights of the prisoner. Defendant's subjective expectation conflicted with her own knowledge. Amen, Judge Everett. Charles Adelson was arrested on April 21st, 2022. The portion of the conversation defendant seeks to suppress occurred on November 7th, 2023. That period spans a difference of 565 days. I feel like this is a throwback to Zadie Kranick. He's counting days. Remember Donna on the stand was like, however many days, hours, minutes she was incarcerated. Judge Everett is like, I can count too, boo-boo. Did you count these days? How many days were you getting calls from your son before this happened? Based on the sheer volume of calls between defendant and Charles Adelson, she, cannot reasonably claim to have been unfamiliar with how the Leon County Jail facilitates phone calls from inmates. This asserted subjective expectation became less and less reasonable with each time she answered a phone call from the Leon County Jail, consenting to recorded calls until both parties are disconnected. So in other words, ma'am, you're not new to this. You know how this happens. It would be different if this was like his third day in and you were confused. But over a year, you knew what was up. She cannot even claim to be unfamiliar with what transpires when a Leon County inmate's phone is disconnected, because she is heard acknowledging on the November 7th, 2023 recording that her son had been disconnected for the 4th time, just in that day alone.
Mama.
Yeah.
Mama.
What's wrong?
Mama.
Mm-hmm. Okay,
Mama.
give me 1 second. Defendant testified her son was frequently disconnected during their phone calls he made from the Leon County Jail. During these other instances, defendant answered she would ordinarily hang up the phone after he was disconnected. Are you getting down? Okay. Suggesting she realized she needed to hang up her phone to end or terminate the call. Thus, rather than expecting her phone would automatically disconnect, her own testimony reflects that she was aware that calls from the Leon County Jail would continue unless and until she hung up her phone. And I feel like on the stand, she was trying to make it like it was faulty. Do you know? I mean, and it very well may be faulty. I'm sure it's not it's not performing as expected. But the fact remains, she knows how it has been performing. So she has no reason to think on this call it will perform in some other way. Not a reasonable reason. I mean, if she's trying to get it suppressed, I guess you pretend. You insult the judge. So expecting an opposite result or outcome from what has taken place previously and repeatedly is an expectation society is unwilling and unprepared to recognize as reasonable. Doing the same thing and expecting a different outcome, crazy. A person who knowingly operates a device that is capable of inadvertently exposing her conversation to third-party listeners and fails to take simple precautions to prevent such exposure, such as hanging up the phone, does not have a reasonable expectation of privacy with respect to statements that are exposed to an outsider by the inadvertent operation of that device. Figure out how to hang up your phone, Miss Adelson. See also United States v. Monker. Any expectation of privacy in outbound calls from prison is not objectively reasonable, and the Fourth Amendment is therefore not triggered by the routine taping of such calls. Conclusion. We're going into our last page, guys. For these reasons, the court cannot conclude society is prepared to recognize as reasonable defendant's subjective expectation of privacy in the November 7th, 2023 phone call. 1, the phone call was received from a jail or correctional facility with a valid interest in preserving security by continuing to record phone calls until both parties of the call have disconnected their phones. 2, defendant's subjective expectation was contrary to her own familiarity with the Leon County jail phone technology and prior user-based knowledge. And 3, expecting different outcomes or opposite results from what has repeatedly occurred is intrinsically unreasonable. Okay. It is ordered and adjudged that defendant's motion to suppress is hereby denied, done and ordered in Leon County. Oh, yes. Hey, Google, stop. Okay, where'd you guys go? Oh my God. Here we are. I love Judge Everett. Like, he told it like it was, didn't hold back. Hey, Drunky the Bear. How goes it? It is a little, oh, these are from, I think, last night. I'm not up to today. There we go. In the morning. Over and over again and expecting a different answer. Absolutely. I love how he laid it out. I think he's very patient, like, and is no nonsense, but also has like a good sense of humor. I think just for the risk of her suicide alone, he had to deny the bond. Like she said it. I've lived a good life. Harvey and I will just take something, go to sleep. We know he is still, it still has his license as far as I know, and previously was giving out medication to her. Charlie was giving out medication to Wendy, Jeff Lacoste said that. And then good morning, Emily C. So it's just a whole bunch of like foolishness going on, but I'm glad he came back with that. And a lot of people were like, what's taking so long? And I'm like, he's going through all the citations. He's buttoning it up because this, as all lawyers are, or as all judges. What happened? You want to get down? You want to get down?
No.
Okay, well, what do you want to do?
This. This.
Okay, I don't know what you're saying.
Pug?
What do you guys think about Sigfredo? What is she gonna ask? Like, what is it? I hope he just takes the fifth. Okay. Mm-hmm. Boop, boop. Not sure. I came up with that while heavily medicated. Donna's cross to follow. Oh my god, I just can't wait for her to be taken down. I feel like the evidence is overwhelming. It's the same evidence against Charlie, except she actually wrote checks. She can't explain why she was at Charlie's house. Katie's saying that she showed up with wet money. Charlie went outside. I mean, you've got great circumstantial evidence. You've got, I don't know if it's eyewitness or ear witness, because I don't think Katie went outside. But it's just, and then why were you getting a one-way ticket to Vietnam if you didn't feel you would be implicated in anything? Do you know? Like, yeah, vacation, but in an emergency, why didn't you take a vacation? I mean, what were you doing during Charlie's trial? Do you know? It's just, it's unbelievable. I think she knows her fate is clear, and I think definitely they were going to do a suicide pact. Harvey and his nurse, I don't know what to call it, he's not looking good. I think she should just put him at rest, take the deal. She's 75. You're going to die in prison, honey. Like, that's just the way it is. You're going to die in prison. You're guilty. And you've had 11 more years on this planet than Danny Markell did. And it makes me upset, too, that they still are not letting the Markells see the children. Wendy left to Texas. And it's sort of like, they had the law changed in Florida, the Markells did, but then she leaves the jurisdiction. It's her hatred for Danny that rules all her decisions, and Donna's hatred, like we saw in the letters. It's rough. It's rough. And it's like the people that listen to these calls don't know the tricks exactly. Right. They know all the code words, all the tricks, all the, yeah. They read between the lines. It's like Sarah. Oh, I did that one. Okay. I still want to know if she's really never watched any police drama or mafia thing to not know what laundering them. Yeah, I still can't figure that out. Did she think like she was washing away their fingerprints? Like, laundering money is making it look like it came from somewhere else, not actually getting dirt off of it. So yeah, Donna continues to think she is special and above the law. You want some tea? Okay, it's a little hot. A woman who wanted to change the religion of the grandchildren just to piss Markell off. Yeah, she's selfish. And imagine, like, the children are old enough now to read that and hear it and understand, like, the magnitude of it. The youngest one just had his bar mitzvah, last year? It was either end of 23 or end 24, because I remember people were posting pictures of Wendy and her cleavage all over. And then I think Ruth Markell reached out to some creators and asked them to take it down because it's still, it's a sacred event, irrespective of the foolishness of the child's mother. Barb, you made it back. Sorry about earlier. It was all about Sugar Bear last night. So yeah, that is it. We've got Katie McVanois coming. We've got Charlie coming. We've got the Sigfredo depo happening. They're gonna go to the jail, apparently, to the prison. He hasn't said anything. What's wrong? Up? You are up. Oh, your leg is stuck. Okay. All right, we're gonna go and get our day started. The boss is awake and bossing, so I gotta I did ask for the WhatsApp messages that they referred to. There's a backlog. They're saying it's going to be a while. These would just be the ones about Vietnam, but I'm curious as to what else they have, like I said before, on her phone, if she's not deleting any of her messages. Time will tell. I can't remember, and I can't find the order now. Do you guys remember if they also seized Harvey's? Because I'm like, I don't know if they would have reason to do it, or maybe they do because they're married. I'm not sure, but I know they came back like after Donna was arrested, went to her home to get devices. Maybe they shared all the devices. Hello, how are you? Um, yeah, so if they did get Harvey's devices, that could link in Harvey. We know Harvey knew something though, right? Because he was at the sushi place with Charlie talking about it. And Harvey was like, oh, I didn't think it was them. I didn't think they were that smart. When Charlie was like, I think it's the feds or I think it's the government and it's not whoever in jail, Katie's friend. And Harvey was, oh, I didn't think they were smart enough to do that. So he at least know, but I guess he could then say he only knew about the conspiracy or he was told it was a conspiracy. But then he'd be throwing his son under the bus who's still appealing it. I think, I mean, I want them to get Harvey, but I understand why that might not be the best bang for their buck, right? As long as they get Wendy, I don't care. And I hope, like, in my dreams, before Donna's verdict comes in, Wendy gets some new bracelets, but they'd have to extradite her and all that other stuff. I mean, she still has that one slick attorney, but the way she fought for her phone when the police wanted to take it. There's stuff on there. Oh my God. And she was wiggling. I would never do that. Maybe it's my own. I would not be wrestling with the police about anything. I guess because she's older, she knew they weren't going to wrestle her to the ground. But I've seen too many bad cops to be like pulling away a phone. My attorney said, no, ma'am, like, I think they thought they were going in for like an interrogation or their entitlement is just ridiculous when she's like, my husband has to come with me to the jail, ma'am, to the women's jail. So maybe she thought she was going in for a talk and that's why she didn't want to give up her phone and wanted her husband to come with her. So, because even then she was laying it out, like, oh, he's 80 something. He won't be able to get home, ma'am. From the airport, he can't go outside and get in the cab. From the airport, is he okay? Like mentally, is he okay? Such a Donna move to volunteer her husband to sell. Yeah, I know. As much as Harvey should be charged, it would be a complete waste of money. He does not look like he can make it to trial. That's what I was thinking, like from just the resources of the state. But again, it does annoy me that they had 11 more years than Dan Markel had. It's their entitlement. All right, guys, that's all I have. I don't want to hold you again. Apologies for last night. I appreciate you guys so much. You know, it's mom life. And good morning from New York City. Hello, Kathleen. Okay, wait, let me just say the sassiness and disdain that Donna demonstrated at her first appearance has gone to the wayside as she attempts to appear feeble. Yes, but you notice when she was with Sarah Dugan on Cross, she got a little feisty. I think she's got to get on the stand to explain why she wrote those checks, what she was doing near Charlie's house before, what was the text message, because remember she was like something about she couldn't talk until they were at a rest stop to talk to Charlie, and then she was like, oh, this is going to be the best birthday surprise for the dad. Originally they were going to do it in June, which also, coincidentally or not, Father's Day, Wendy and Katie and Katie's friend and Charlie were all together, and that's where they have that photo. Georgia keeps asking Wendy about that photo and how many times and if she sent a WhatsApp ever to Katie, and Wendy doesn't answer. I think Georgia has something there. Yeah. And I don't know. They would have already seized Katie's phone by then, so maybe they got it off of Katie's phone if she didn't delete the WhatsApp. I just feel like there's a lot. I know people were like, oh, they would have gotten Wendy already if they had it. I don't know that that's right, and I don't know that we have all the evidence that they have, even though I get it. There's all these like big lawyers who are like, oh no, I have faith in Georgia Kappelman and Sarah Dugan. I have faith that they are going to take Wendy down. I think it's personal at this point, even though it shouldn't be. Just the fact that she thought she could get away with this. It's the audacity. I think she has. Yeah. Are you wearing my Tiffany's bracelet? Just the fact that she thought she would get away with this. She thought she was so clever, and it's all because of her. even in the email exchanges, she's like winding up her mother to wind up Charlie, and then she steps back. Even in the one email where she told her mom, presumably, that she was trying to make peace with it, because Donna comes back with that in her letter, like, make peace with it. Like, she started the fire knowing she was not going to be able to put it out, but she feigns putting it out in writing so that if those are ever found out, she can say, well, I didn't ask them to do that. She didn't, but she did, because she knows how they are, right? It's just like if you are, I'll say this, I'm going up some stairs with a stroller and someone comes to help me. I didn't ask them to, but there was a high probability. And I didn't say, no, don't help me, right? She never said, no, I'm not going to do this. And who thinks, yay, who thinks they killed Dan Markel without consenting, Wendy? I just don't believe that. She had to say, okay, I'm down with this before they actually did it. I just don't believe they would have done that behind her back. And then the whole thing about her having kids, it seems like it was to please her mom. And she's, in my opinion, needy, right? And so maybe she saw what happened with Rob, the older brother, and him, being exiled, and then they figured it the F out. She didn't want that to happen. I mean, she and her mom went through J-Date together to pick out Danny. And I think they were just picking out DNA. Like, Donna wanted beautiful Jewish grandchildren. And Danny and Wendy were, objectively a good-looking couple. But I don't think Wendy wanted to take care of the kids. And so when she had the divorce, she was, like, quote unquote, stuck watching her kids, as her mom says. And so in order to alleviate her of that responsibility, her mom said, well, come down to Miami and I'll be the mom, which she did, after Dan was unalive. So, yeah, Wendy definitely knew. She had to. They're too enmeshed for her not to have known. The dad was calling because the day of the shooting, which the guy has passed. What is it? The Geek Squad? I can't remember what brand that is, but whoever from the Geek Squad, that guy passed. But like, he had called, but he ended up calling Harvey, or calling the house. Maybe he was looking for Donna, and Harvey was like, no, you got to call over here. So all of, like, why couldn't you take the message and call her yourself? Because they're building Wendy's alibi, right? And they want to make sure that the Geek Squad gets in touch with Wendy so that her window of alibi is solid, but he comes early. And so then she's left without an alibi for the actual time of the shooting. No one thought you did the wet work, Wendy. Okay, we're going to say bye now?
Bye.
All right, guys, the boss has spoken. I appreciate you guys all. I will talk to you later. Toodles. You say toodles?
Yes.